All right. Welcome everyone to our bed talks. I'm so excited to have everyone here, and I'm really excited to have Peter here talking legal matters. I was very excited to meet Peter at Hershey at the Pet Boarding and Daycare Conference last fall. He has become very highly recommended from a lot of other reputable professionals in the industry. He's been a delight to talk to work with, and I am always going to take advantage of the opportunity to ask a lawyer questions. So hopefully that will benefit you all as well. And without further ado, thank you so much, Peter, for coming to talk to all of our pet care professionals.
Pat, thanks for having me. I really appreciate the opportunity, and I'm looking forward to having a conversation this afternoon. And I look at it as a conversation. I'm going to go through various scenarios, and please feel free to drop a question, any questions that you have in the chat, and I'm happy to answer any of them. And if I don't get to all of them today, you can always reach out to me afterwards, um, and I'm happy to address it. It's funny you talk about to take advantage of a lawyer. I went to the car dealership yesterday, go pick up my car for another repair, and the guy pulls me aside. He's like, "Hey, can I ask you for some free legal advice?" I didn't even know. I'm like, "What do you need?" He's asked me some questions. I'm like, "Yeah, that's you can do that." Do I get a discount off my car? I was laughing. He's like, "No, no, no." So it's all good. So I'm going to talk about legal considerations for pet care professionals. Let's dig in here. So um, first, before I get into the presentation, I wanted to just kind of give a general overview of what we do here at our firm, um, and types of matters we've handled for our clients in the industry. Um, we've built our team as a 360-degree approach. So what does that mean? You really have, if you see here, we can work with our clients. I always like to say from the cradle to the grave and everything in between. Whether you're an existing business owner, you're looking to start one up, you're looking to acquire one, you're bringing on a partner, and everything in between. We really were able to kind of pivot with our clients, and it keeps it interesting. But we have the ability to do that. Over the past few years, we've handled a number of just straight up acquisitions, um, startups, development projects out west, multiple sales to strategic buyers, and everything in between. I think one of the things that also kind of sets us apart is, as Beth indicated, I think I know we're strategically positioned with a lot of other industry professionals, folks at the TWC and Live Oak, where we could bring in the expert if we're brought to the table first, or a lot of times, one of our industry partners is bringing us in almost like a surgeon. You're kind of coming in to handle that particular matter. And a lot of times with the startups, the acquisitions, um, we'll handle that. And then we're positioned as your outside general counsel on a going forward basis. So you can send email, text, call, whether you have an employment matter, you're looking to do something else or expand. We will have a conversation around it. So it's almost like your accountant, your outside CFO. We position ourselves as your outside uh, general counsel. So some of the things we're going to talk about today: buying and starting a business, what legal entity to choose, due diligence, and then some trying to the pitfalls you try to avoid. I hate to say it now, I've been a business attorney for almost 30 years. I can't believe that's coming out of my mouth, but it's almost 30 years. But as a business attorney, um, the thing that you want to do is you want to be proactive, not reactive. So you're trying to provide clients with advice up front. So down the road, if there's an issue, you have a roadmap. And that's some of the things we'll talk about today. And I just kind of highlighted, who should be here. Entrepreneurs, existing owners and investors. Because I think we're going to touch on a bunch of different things that will benefit um, each one of these types of individuals. I always, no matter what I'm talking about in any presentation, I always start and lead with this slide. I can't emphasize the importance of building your team. Um, just from my experience over the years, uh, you know, when you come into a particular project or a transaction and you're working with maybe an accountant who is um, a family friend, or I have a lawyer on the other side who is a friend at the like local golf course, golf club. It creates tension. You want to build your team with someone experienced in the industry. Uh, Whether it starts with your accountant, your attorney, whether it's us or someone else who has experience within the space, your lender, your financial advisor, and whether it's a consultant or a broker who may be working with you to list your business for sale. Um, Talking about being proactive, this is very critical and why I spend a lot of time on it because you can see time kills deals or transactions or agreements. And when you're working with somebody who doesn't really understand what they're doing, I find that you're going to end up spending more time and more money um, working on it. So think about it. Build your team. When you first go, you go to the Hershey conference and you're looking for somebody in particular, you ask that person, who else would you recommend? And, listen to them, interview them, make sure they fit with your team, um, but also they have the experience what you're looking to do. All right. So I'm going to talk really initially about acquiring a business, things that you should consider. What could go wrong? And a lot of it, is no difference than I always like to use the analogy to, personal relationships that we have. You have somebody, they become your friend, but that friend isn't who they turned out to be. They're not going to be your friend anymore. So when you're looking at a particular business, I find it now more than ever, um, culture is really important to our clients who are looking to buy a business. Um, what's the culture of that business? How has the staff been treated? How has the owner acted through the years? You want to get a good feel for that to understand what you're coming into. Um, is it the right fit for you? What kind of philosophy they have, in terms of running their business, how they treat their staff, how they treat their clients, what do they do? Um, the management styles, understanding how they manage their business. I find it's very important because you don't want to have culture shock going in there when you buy that business with their staff. Um, and time delays. I'll say that a couple times. Whether you're starting going to do a startup, you're doing ground up construction, you're buying or you're selling, time. Time kills deals. What does that mean? Delaying. If you're going to be the bottleneck on getting information or to your lender, to your accountant, to your attorney, those things cause delays and eventually could ruin the deal. Once you're mentally set on doing what you're going to do, you want to be working with your professionals to move it along. If there's a strategic reason why you may want to delay something, you'll talk about it with your attorney. But otherwise, you don't want to be the one who's delaying the transaction. Um, if you're when you're buying, determining the valuation, understanding what the business is worth that you're looking to buy, and you're going to do that either with your accountant. Obviously, you're going to be working with a lender like a Live Oak, who's going to maybe help you out with the transaction. They're going to do their own valuation, but you want to understand what that business is worth, so you feel like, okay, that makes sense to me. I too many times where it's not surprising. What do you think? Buyer feels like they're overpaying and the seller feels like they're underpaying. And right away, there's a tension for it. That's why when you determine the valuation, what they call a fair market valuation, maybe by an independent independent third party, it takes away that tension. The parties may not always agree, Because a lot of times the sellers still want a certain number in their head, but at least you as a buyer can get your arms around and say, okay, this is what the market is calling for this business. Um, I'm willing to pay that. And I know the seller maybe wants X amount of dollars more than really what it's worth. And you want to be talking again with your accountant and your financial advisor and your lender. Okay, if I overpay for this business, what is that going to look like? Because maybe it's still a target that you want to acquire, and then maybe you have some ideas how you can grow that business and kind of back into that number. Um, Finding out the valuation, you've looked at it, you think the price works for you, a letter of intent. And where I'm going to go into details more about a letter of intent, but that's like the one of the first like shots across the bow that the parties discuss to kind of really get into the weeds of the deal. Um, do your due diligence. Um, Doing your due diligence for anybody who's bought a home, residential home. Doing your due diligence is, in my world, it's the same thing when you go buy a home. You got to do a home inspection. You're walking through with your partner, your friend, your spouse, and looking at every nook and cranny in that house with the home inspector. Oh, that receptacle's not here, or this is not here. You want to look and you want to understand. It's like your opportunity to look under the hood of that business. And I always, to see if there's any issues so we can work together to address them prior to closing. Real estate consideration. So you're buying the business. What are you doing with the real estate? Are you buying the real estate, or are you going to be entering into a new lease with the seller who owns the real estate, or maybe the seller doesn't own the real estate. Maybe the seller leases it from a third party landlord, and then what you would end up doing is buying the business, and then you're going to enter into what they call an assignment and an assumption agreement with that third party landlord. So there's three parties. It'd be you as the buyer, the seller, and the landlord. Um, with your real estate considerations, similar to the valuations on the business, if you're buying the real estate financing, how are you going to finance it? What's the value that the real estate? And a lot of times that's a lot cleaner to do a fair market analysis of the real estate to get an appraisal done on it. Land use is a big issue in this space. Big issue. A lot of times when you're buying the business, it's already been approved. It's in a zone, or they got the variance in order to approve the use that they're doing as a kennel or a boarding facility, which is good. You as a buyer, as part of your due diligence, we're just going to dot our I and cross our T's and make sure that you've got the proper zoning for the use that's anticipated. And maybe you're looking to expand that use and to do some type of other service. We want to explore it during due diligence to see whether or not you're even able to do that. Um, you want to buy the building. Maybe it doesn't fit your needs or what your goals are. Can you expand it? Can there be development on that property? You want to know about that going in, because if you can't and you buy it, then all of a sudden, geez, I'm buying this. It's 3,000 square feet, but really what I'm looking to do, I want a 5,000 or 7,000 square foot building. But if you're not able to do that, you want to know that up front. Um, Construction law, dealing with the contractors. That's something we'll work with our clients on. You know, you're gonna buy the building, and then you're going to maybe do an expansion, or you're going to do a development. We're working with you to look at the construction agreements, the architect agreement, making sure that what you're agreeing to in those time frames and any type of financial considerations, that you understand what you're doing, and making sure those time frames fits in what your plans are. And then I talked about owning or leasing. Um, as a business lawyer, if you're able to own the building where you are operating, it's always the better fit. Um, when you talk with your accountant, he or she will agree with that. It's almost you could take you can pay yourself your rent, and you're building two assets at the same time, your business and your real estate. That's not always the case. Sometimes what will end up happening, is from a financial standpoint, you can only buy the business, but you have a desire to buy the real estate down the road, or you want to buy the business and you want to buy the real estate, but the landlord's just not ready yet to lease to you. So what do you do in that situation? When we're negotiating that deal, we're looking at that lease that you're entering into, and we want to make sure you have the ability. So if you want to buy that building at some point in time, we want to make sure you have the ability. What we call an option that you control. Maybe after 2 years or 3 years of the lease, you as the tenant have the option to say, hey, landlord, I'm ready to buy. Here's my offer. And there's a whole mechanism already set forth in that lease how the business is valued, the time frame around the offer, the time frame around the acceptance, when you're going to close. You map it all out there. So when you're into your lease, you don't go to your landlord and you're locked in, and your landlord's like, whoa, well, and starts, playing games with you. It, the roadmap is already set forth in the very beginning. Um, is also another way to appease a landlord who's not ready to sell to you. So I'm working on a deal right now with the client. Landlord's not ready to sell. I said, well, why don't you find out from him when he would be? Is it year 2, year 3, year 5? Because he wants to still get some rental income. So, and then if you find out what the term is, then we can build that option and say, okay, landlord, I know you don't want to sell me now. You're telling me you wanted 3 more years of rent. I'm okay with that. But just to still we're on the same page, I'd like to have an option then at year 3 that at any time after year 3, I can exercise it. I don't have to, but if I want to, I can. And then you're also kind of fleshing out what the landlord is really saying, if he what he's saying is really true. Because the last thing you want to do is get into a lease arrangement with a landlord and you have this no desire to buy it and they have no desire to sell it to you. I think a lot of our clients also get confused between what they call an option, which you control as a tenant, or right of first refusal, which the landlord is obligated to give back to you. But a right of first refusal doesn't give you any ability to force a sale on the property. The right of first refusal just requires the landlord, if the landlord gets an offer from some outside third party, the landlord has to come back to you and say, hey, I got this offer. Do you want to match it? If the landlord never gets that offer, you have no ability to match it. So you just want to understand what you're looking at there. Okay. So this is just an overall picture of what the transaction looks like from the beginning to the end. Okay. And we'll go into more detail about each part of it. A lot of times with the transaction, we'll start with a non-disclosure agreement. If I'm representing the seller, before I have my client give a potential buyer any information, I want the buyer to sign what they call an NDA, depending because I don't want to be sharing. I don't want my client to be sharing their financials. Excuse me, maybe a customer list, um, referral sources, how they do their business. If you're going to look under the hood of my client's business, I want you to sign an NDA. So in the event that we don't do the deal, you are bound by that non-disclosure agreement, that you cannot go ahead and use that information against me. Also, a lot of times when you're doing a deal, the non-disclosure agreement will also have what's called the non-solicitation provision in there, that you're not allowed to solicit any of my employees. Now, a lot of times when a buyer's coming around to a business, it's after hours. But if it's not, and the seller's a little more loose about it, and you're walking around there, or maybe you even know that business and you know the employees there, and you're coming around there, the last thing we want to do is, you're going to the my sell no, this my client's business who's looking to sell, and then maybe you meet Jane and you meet Pete and you like them, and then I don't want to do this deal. I'm going to go look at something else. But then all of a sudden you try soliciting my client's employees away from them. That will um, that will prevent that from happening. Um, matching with the right buyer and seller. That's kind of going back to I initially talked about culture and fit. If you're working with a broker or a consultant to kind of find what kind of, where you want the business, what kind of business you're looking to buy, um, how big, how small, what location, and then whether culture fits for you. Letter of intent for both parties. Um, that's the initial, like I said, shot out over the bow, which I'm going to talk about right after this. Um, Transaction financing for the buyer. At the same time, it's like walking and chewing gum. You're out there looking to buy, a facility. You should be talking with a lender upfront, understanding how much you can afford and getting that process going. Again, you don't want to be the delay. Um, in the process. Negotiating the transaction documents. So the letter of intent gets signed. You're working on your financing. Then the lawyers are taking that letter of intent, which is the blueprint for the deal, and they're working on the contracts. So the contract's going to be the purchase agreement, and depending on what you're doing with the real estate, it's going to be the release or real estate contract for purchase. Um, Due diligence, that's ongoing. A lot of times, the due diligence starts once the NDA is signed or the letter of intent is signed. Sometimes there'll be an NDA signed. Buyer looks under the hood. I want to make an offer. LOI goes out. And sometimes in that LOI says once the parties sign it, the buyer can start doing their due diligence. Or sometimes it'll say, okay, once the LOI is signed, parties will enter into contracts, and then the contract will have a date to do your due diligence. Um, and then you're going to get to a closing. And then once the business close, you close in a business, sometimes there's a transition period for the seller or sellers to stick around, help you get your feet on, introduce you to the clients, introduce you to maybe referral sources, introduce you to the community. Sometimes there's a transition, sometimes there's not. So before I get into the letter of intent, and I know there's a lot. Any questions? We'll stop there.
Do you find that often a transition period is more than likely a better option if you can get the seller to help you transition? Or do you find people kind of come in and they're like, you know what, we're doing everything different, and that works too?
Yeah, great question. I think a transition period, even if it's as minimal as having the seller available via email or on their phone for a contractually period of time, is really good. If the seller is willing to stick around, for a period of time, whether it's 30 days, 6 months, depending on what you want to do, you should always take advantage of that. Sometimes there's maybe the seller will work for you for a short period of time, or just be a consultant to what they call transfer the goodwill of the business. Um, as to change everything, you know, it's good to change is good, but you also don't want culture shock with the employees, right? So maybe over a period of time, you're going to find out, what employees are maybe rock stars and maybe which ones, you don't want to have. I guess the shorter answer is it's okay to change, but I, you typically don't see it happen all at once
Mhm.
um, for a successful transition. It kind of happens, it's staged over a period of time.
Okay, good. I don't think there's any other questions,
Yeah.
but I'll
Okay.
let you know if we see any.
Okay. Um, Letter of intent. So I mentioned this is so non-disclosure agreement gets signed. The seller, the seller exchanges information with the buyer. Buyer's interested in making an offer. This is the offer. The letter of intent, it outlines the preliminary terms of the deal. Um, a lot of times it's prepared by a lawyer. Sometimes it's prepared by a broker, and then sometimes it's prepared by the parties themselves, which it's not always a good thing, but it happens. Um, it's not legally binding, meaning even though both parties sign it, um, uh, it doesn't require the seller to sell, doesn't require the buyer to buy. What it does do, whenever I'm representing the buyer, I do have a couple you do have a exclusivity provision I like to put in there. So if I'm spending time and money as a buyer, or my client spending time and money as a buyer to look at that business, and then the letter of intent gets signed, what you do is you have an exclusivity period in there, maybe for 30 or 60 days, that prevents the seller from soliciting or receiving other offers. That seller is just looking at you. Again, I make the analogy to like a attorney review period in residential real estate. I remember with my wife when we're looking to buy a house, we made an offer and then we're going home or we're telling our attorney, get us out of attorney review, get us out of attorney review. So then I know I have a binding contract. It's similar to that because once the seller signs a letter of intent, the seller's focused on you for that window of time. You're doing your due diligence. Now the parties, there's contracts being drafted. The last thing you want to be doing is spending time and money, and all of a sudden the seller comes back to you and says, "Hey, I know you're offering me $1.2 million. I got an offer for 1.3," and then you want the seller retrading on you. So that prevents that from happening. That's what the exclusive. And then the confidentiality kind of works, more for the seller's benefit. Any information again they're signing, providing to you, it's kind of belt and suspenders with the NDA because sometimes the NDA does not get signed if we're not involved early on. And then if I'm representing the seller, I'm gonna dot that I and cross that T in the letter of intent with the confidentiality provision. Um, I find the letter of intent saves times because if you are unable to agree on basic terms and a letter of intent that's non-binding, you're going to have a heck of a time, trying to agree in a contract. And the last thing I want my client doing is spending time and money frivolously. No matter what they say about lawyers, a good business lawyer, I don't want you doing that. I want to make sure you're being efficient with your time and your resources. So the letter of intent kind of fleshes all that out. Um, it's really the roadmap for the deal for the parties. It's going to talk about timing, right? How long for due diligence? When does it start? When does it end? How the what's the financing terms going to be, or the money, how much you're buying it for, how much there's going to be deposit, um, how much are you financing? Are you financing 100%? Are you financing a part of it? Are you financing a part of it? And then maybe since the seller wants a little more money, is the seller going to say, okay, you're financing X, but I want this number. The bank's not going to lend you any more money. And maybe the seller's like, I'll seller finance the remaining balance. Things like that. Deal contingencies. I look at these as doors. Okay. When I'm representing a buyer, you want as many doors open that you can go through. And if you're unable to get out of a deal, obviously a financing. You're not buying the business if you don't get the financing. You need the money. Um, Due diligence. Um, if when you're doing your due diligence, if something comes up that you don't like, and even if the seller can remedy it, you still don't like it, you want to be able to get out of the deal. Clear title to the assets and also the real estate. Um, we always do what's called a judgment in lien search on the seller, which a lot of times is a business entity and the principals of the seller, though who the members are. We want to make sure that if there's any loans or if there's a claim or some type of judgment against the selling entity or any of the principals, they are satisfied and released as the time of closing. And then what party is going to prepare the documents? Uh, I always like to, whenever I get brought into a deal, before we do anything, we have the letter of intent. If we haven't spoken with the attorney yet, I always ask my client whether you're buying or whoever's buying or selling. I like to speak to the lawyer, and then I get on the phone with the lawyer. And you want to be an advocate for your client, but an ounce of honey goes a long way. And talk with the lawyer about, okay, what do you want to do? What do you want to draft? What do you want to prepare? And a lot of times the buyer's attorney will draft the purchase agreement for the business, and then the seller's attorney will draft either the lease for his client if his client is the owner of the real estate and is going to lease it to the buyer, or if the seller also owns the real estate and the real estate's going to get sold along with the business, the seller will prepare that. The seller's attorney will prepare that. But you want to have a conversation around it. The last thing you want to do is be drafting documents and you send it over. And I've had this happen actually many years ago as a young lawyer, and An attorney said, "Well, I'm not using it. I'm using my own form." It's a lesson learned. Um, don't want to you want to avoid. Excuse me. Obtain your financing. So I talked about contacting your lender. And a lot of times, you go to Hershey, you see Live Oak there. They're there. They're accessible. We do a lot of work with them, and they can provide you with a wealth of information. The pre-approval process. It's just a great way to be prepared. Again, you understand what your budget is. You're speaking with them. They're looking at your personal finances. And then they're talking with you about what type of business and what's the size of the business you're looking to buy, if you're buying your real estate. Um, Part of the financing, I've talked with them a lot about this too, the lenders, understanding what the zoning is for that property, again, making sure it's the right zone, it's zoned properly. Um, Once you have that in place, you're submitting your LOI for the purchase. Um, and as that's all going along, the pre-approval eventually will turn into a formal approval. And the formal approval, again, is another roadmap basically for the deal. Us as your attorney are using that formal approval from the bank. That's our checklist. Um, I always say, he who makes all the gold makes all the rules. And obviously, you're not doing that deal without the financing. So the bank has certain, procedures that they want followed. So you got to go through their checklist, and we have that in front of us as part of the deal. We're working through it. Uh, Judgment and lien searches. You're buying the real estate, making sure, from an environmental perspective, there's been an environmental study done, things of that nature. It's a whole, it's like a 3 or 4 page document that we're going through, and we're working with your lender to satisfy all those, because they're not going to issue the loan for closing until their checklist is complete. Um, let's see here. All right. Kind of going through, the financing. Just I want to kind of break it down a little bit more in terms of this. So, I always say, financing is just not about getting to a closing. It dictates, your operating freedom, your risk tolerance, and your exit options. These are, whenever I look at the financing, I'm talking to our clients. Can the business service the debt conservatively? That's 101, right? Does the structure the structure allow operational flexibility? Does the timeline align with the deadline realities? And good. Why you want to work with a lender in the space is because they're going to understand the timelines that are involved in your transaction, and not going to provide you with a timeline that you may not be able to achieve. And does the loan allow for a clean exit in 3 to 5 years? Um, Prepayment penalties, you want to take a look at that. If there are, a lot of times there are prepayment penalties, which is normal, because the bank wants to make money on their loan. That's why they're lending you the money. And if you're going to turn around and pay it off right away, they've already budgeted, the kind of money they want to make off of that loan. So you want to understand what your the prepayment penalties are, and how that looks. Um, Over leveraging risk, as anybody who's in this space, uh, cash flow volatility. There's seasonality, staffing shortages. You want to make sure if your revenue drops, will the loan still work? Um, you see the timeline. I'm thinking timeline is not driven by the lender. It's really driven by your readiness. What does that mean? Once you start working with your lender, uh, again, starting from the beginning, you don't want to be the reason for a delay. You want to move that loan along. They're going to be asking you for a lot of information. So when you're thinking about buying, a facility, you want to have your financial records in order. Because the bank is going to need all that information in order to process their loan. Don't be the bottleneck, and get them the information that they need so they can move the deal along. And also, it talks to your seriousness as a buyer, that you're prepared. Let's see here. All right. I spend a lot of time here, more especially when I'm doing presentations. Um, in in this space here, I find that it's amazes me still how this is kind of an uncertainty, and it's really important. Uh, and this is why you're working with your attorney and your accountant, kind of dovetailing. So I kind of listed the various types of business entities out. Why are you forming a business entity to begin with? Uh, it's very you're going to form at least one, if not two, when you're buying the business. Okay, if you're buying the business and you're going to enter into a lease, you're just forming one entity. If you're buying the business and you're going to be buying the real estate, you're going to be forming two entities. So let's kind of go through. Back in the day, they had these sole proprietorships, general partnerships. I say back in the day, even before my time, when I was practiced as a young lawyer, I saw a lot of sole proprietorships and general partnerships. Why? Because the limited liability LLCs, they hadn't arrived yet at that time. So there, no business owners back then were a little more limited of what type of entity they can form. The problem is with a sole proprietorship or general partnership, especially in this industry here, there's a lot of risk involved, employee claims, property damage, dog bites, anything like that. You think about the entity, it's a shield for you. Okay, so let's kind of go through these. Um, Corporation, all right. Uh, Corporation. That is the your that is that. So there's always a sole proprietorship, general partnership, and the corporations. Um, it's clean for like liability, a clean liability shield, but it's rigid. What does that mean? You form a corporation. So if you're ABC Pet Boarding Inc., um, unfortunately, when the corporations came about, every state has what those statutes that govern corporations. And if you look at those statutes, they are very rigid. They require annual meetings. There's a lot of requirements that even if you're the sole owner of that corporation, that you're really supposed to follow. Why does that matter? Because in the event that you don't follow the statutory requirements of a corporation, you run the risk of, if there's a lawsuit, a buyer coming to kind of making a claim that, oh, you weren't operating properly as a corporation. And what you can pierce the corporate veil, like they say. You can get through the corporation at you personally as the owner of the corporation, which defeats the whole purpose of having a corporation. So you had the corporations, and then and then the corporations, you have the S corporations and the C corporations, are two types of corporations. C corporations, again, old school. You don't see that anymore. There's double taxation there. You're getting taxed when money's coming in. You're getting taxed as an entity. You're getting taxed as a shareholder in an entity. You just don't see it. I wanted to put here just so you understand it. And I'm going to talk about S corporations, in a second. So, a lot of times your accountant is going to recommend an S corporation, okay, to be taxed as an S corporation. Um, it avoids double taxation, and the income passes right through the entity into you as the owner. And also, the real big thing, the S corporation, why a lot of accountants recommend the S corp election, the owners can split income between the reasonable salary um, and distributions that are not subject to self-employment tax. And if you don't make that S corp election, um, you can be taxed on those distributions. So what does that mean? Get down to the limited liabilities. You had the corporations, and when you become a corporation, you do a C corp or an S corp. Most go to S corp. Then and LLCs came into play in the 1990s. They could the best of both worlds. You form the LLC, which most business owners do now. You form an LLC. And I always like to make the analogy to us as people. Now, when we're born, right, our parents gave us a name. And then the next thing, you got a social security card, right? You got a social security number. The same thing with a business entity. You know, you're going to form an entity, you form the LLC. Then the next step is how do you want that entity to be taxed? That's where your accountant will come in. And most likely, they're going to say, we want to make the S Corp election. So you got the LLC protection and you got the S Corp election benefits from a tax perspective. And why the LLC is so favorable? Remember what I said about the corporation and it's rigid? The LLC just like rip the band-aid off. You don't have those things. If you go look at the statutes that govern LLCs throughout the country, a lot of flexibility there. Yeah, the members can meet; they don't have to meet. It just it provides the a business owner with complete flexibility and minimizing possible exposure to legal risks, which is great. And then you make the S corp election on top of it. You got the tax benefits of an S corp election. The thing they and also too with the LLCs, well, LLCs give you flexibility too, and who can be a member of your LLC. So let's just say, Beth and I want to be, members in LLC, but maybe Beth wants to be, she's the main driver of the business. So maybe she's going to be, she'll get what they call A shares in the LLC, and I get B shares. It's good with an LLC. You can do that. You can't do that with an S corporation. Everybody has to have the same type of, ownership interest. So the only downside to when company or no businesses they have an LLC and they make the S corp election, it kind of removes that flexibility in terms of bringing in other types of members who maybe you're going to go get an investor for your business and you want to be the a member, but the investor is just going to get some type of preferred distribution. You can't do that once you make that S corp election. So choosing a business entity sounds like a very mundane thing to do. Oh, I just formed an LLC. You can see there's a lot that needs to go into it. So you understand upfront what you are looking to do in 3 to 5 years. Like, what's your business plan look like? You're most likely going to form the LLC. Is the S corp election the right thing for you to do? Do the pros outweigh any of the cons along with it? And you want to talk with your attorney. You want to talk with your accountant so you clearly understand going in.
Is your business entity something that you can change at any point in the future, or are you like committed? Like, what if you formed a business
Yeah,
and like Kuranda was formed in 1987?
right.
So an LLC wasn't an option. Is that something that we could have switched to if it was appropriate for us?
Yeah, you can always switch. Unfortunately, there's no it's not easy.
Yeah.
There's a time factor, and most importantly, there's a tax consideration. A lot of companies, and I don't know how, Kuranda was, no, it's really on the tax side. How are they taxed, right? So if you're a C corporation and then you want to change, you've been a long time C corporation, there are significant tax implications that go along with that you got to weigh, again, the benefits outweigh any of the negatives with that. So it can be done, but you got to look at it. What's your end goal? And does it meet your end goal? So I've had clients want to look to switch their business entity, and at the end of the day, they're like, "Oh boy, I don't want it. I'm just going to keep doing what we're doing, and we're not because I don't want to incur that tax liability."
Mhm. What if somebody wants to acquire a partner? Like after the business is formed, 10 years later, they
Oh,
decide they want to add a partner. How to,
sure. Yeah, so and you can do that in the LLC framework. I'm going to vote. You could do it, and I know it's confusing here because it says S corps versus C corps, then it says LLCs. Um, go look at it like it's really corporation versus LLC. So in a corporation, you have corporation. You elect to be a corporation, then you have to say, am I going to be an S corp? Am I going to be taxed as an S corp or a C corp? You elect to be an LLC. Am I going to be? You have the ability to be taxed as um, an S corporation. You can be taxed as a partnership, or if you're just one person, a disregarded entity. You have those types of flexibilities. Either way, whether you're a corporation or you're an LLC, you can always bring on a partner. Um, and the mechanism is similar. If you're a corporation, it's a stock purchase agreement. If you're an LLC, it's a it could either be what they call a unit purchase agreement or a membership interest purchase agreement. How do you bring on a partner? First thing you want to do is get your business valued, understand what your business is worth. So then it's similar to when you're going to go buy the business from the outset, because you want to have a meeting of the minds with your potential partner. He or she's going to want to say, what am I, why are you offering this sell? Why am I paying this? And if you have a valuation of your business, you understand what it's worth. Okay, that makes sense. And also, if they're going to go get financing, the bank's going to be looking at it too. So yes, you can definitely bring on a partner. The first step I always say is get the business valued.
Hmm. Cool.
You
Thank
also, it's a good idea to get your business valued on a regular basis. Spend some time and money, or have a good idea. Whether it's, your accountant can do that for you, or an independent third party, because it's a good way for you to look under the hood of your business on a regular basis. Maybe there's some efficiencies that you could be capturing that you're not doing, that can only help increase the value of your business. And you can do that. It's almost like you're doing your own independent diligence on your business and how you're operating. It also keeps you on track as an owner to make sure you've got good, clean books and records. So it eventually, you're buying this business, you're eventually going to want to sell the business at some point in time. You're not just scrambling at the time when you're looking to sell, or maybe somebody makes you an offer you can't refuse.
you.
Um, it's not like Michael Corleone, and I can say that because I'm Italian. See that, right?
It felt very genuine.
Yes, yes, right, right. Um, so we talked about due diligence, kicking the tires, and this is kind of in depth. The letter of intent's been signed. Parties are working. The attorneys are working on the contract. Um, do your due diligence, and whether it's in the letter of intent or it's in the purchase agreement, due diligence always allows the buyer to walk away for any reason or no reason. Okay. So if you find something you don't like, you control it. That's one of those doors that you control. You're able to get out of it. When I'm representing the seller, what do I want to do? I want to make sure this door gets closed as quickly as possible. It's one less door that the buyer can get out of. So you would want to really just it's your opportunity when you're looking to buy the business. If there's any contracts that the business has, that you're looking to assume, well, make sure that they could be assigned over to you. Is consent required by some third party? We want to get that. I talked about the judgment and lien searches already. Um, we do that for our clients. And if something comes back on one of those searches, we want to talk with our client. How can it be satisfied? Are you comfortable with it? And then we talk with the seller's attorney. And again, say walk away if you're not satisfied. Understanding the real estate. If you're going to be entering into if you're taking if the seller leases a space where the business is, and there's going to be a third party assigning the lease to you. We want to take a look at the lease, understand what it is. You understand, walk with our client through it, making sure that the lease terms fits your business and what you're looking to do. Also, going back to the lender who makes all the rules, the lender is going to lend you X amount of dollars. The lender is going to have a lease term requirement in there. The lender, if they're going to lend you money, wants to make sure that you're going to be in that space at least for a minimum of a period of time. That loan's going to get repaid back. So we want to make sure those two things align too. And we also want to make sure that maybe there's an opportunity there for us as the buyer's attorney, maybe to negotiate some favorable lease terms for you. So we want to take a look at that during due diligence. Um, you're buying your real estate, you're doing your due diligence there. Just like if you're buying your house, you're doing a building inspection, right? We're doing title searches on the real estate. Not only want the business free and clear of any liens and encumbrances, you also want the real estate free and clear of any liens or encumbrances. We're working with your lender to see who's going to do an environmental study. a lot of times the lender, well, it's going to require it. Sometimes the lenders don't, but a lot of times they're going to require it. We always advise our clients to do an environmental study. It costs a few $1,000s. It's by a third party consultant. I always look at it as a shield. If you buy a piece of commercial real estate and that property is dirty and you didn't spend the time, the money to have an environmental study done, that that um, that liability sticks to you upon the time you close. Whereas had you had the study done, one, you find it probably, and if you didn't find it and something comes up afterwards, you can go, if the DEP comes to you and say, hey, there's a leakage from this adjacent property onto your property. Well, when I bought it, I had a phase one done. This is what the results are. It serves as a shield, a liability protector. So it's money well spent up front. Um, Title, survey, survey is going to draw out the four corners of the property, making sure your property doesn't encumber a neighboring property. Or if, a lot of times you'll see maybe fences that are mislined. We want to make sure that they're addressed. You want to get part of your clean title, getting clear title, and then, making sure that the property, there's no encumbrances on your property. Um, I put a slide in here about sellers. I know we're really talking about buying and maybe starting up a business, but sellers, I just want to, it just, you understand, the seller's mentality. I always tell my clients who are looking to sell, you know, there's going to come a time in the deal where you're going to become maybe a little frustrated and fatigued. Similar to what I mentioned earlier, you as a buyer, once you find the business that you want to buy, you want to be focused and go at that business. You want to be the bottleneck. Sellers, once you're ready to sell and you get the process going, you want to be organized and you want to start moving along with the deal. Uh, why I mentioned having your business valued on a regular basis, your financials, they're in good, clean condition. Your tax returns, your income statement, your balance sheets, these are all basic documents that the buyer's accountant is going to be looking for. Um, I think the financial preparation is the most important part of the process because if the financials are a mess, it only has the opportunity to devalue your business. And for the buyer's attorney to poke holes, or the buyer's attorney and the accountant to poke holes into your business. So you want to make sure you have good, clean financial records, because they're going to be scrutinized by the CPA and the lender. How am I doing on time here, Beth? What am I looking? What's oh
We're
yeah.
closing in on an hour, so it's
Okay.
really up to how much time you're willing and able to give us.
Okay, so I can get through. I don't want to rush through. Okay, that's fine.
No,
I'm fine. That's
you're
good.
good.
Okay. All right, great. All right. All right. So touch on with the seller, kind of, thinking about um, so you got the letter of intent. Letter of intent is signed. Now that letter of intent, what serves as the roadmap to the deal, gets turned into the purchase and sale agreement for the business. Okay. It is binding once it's signed. Okay. And like I said, it utilizes the LOI because now you're taking the terms that you negotiate in the LOI and we're incorporating them into the purchase agreement. Um, Deal terms that are negotiated, the purchase price allocation. So if you're buying the business for, let's just say, $1.2 million, the buyer is going to want to allocate as much money uh, of the purchase price towards what they call furnitures, fixtures, and equipment. And I don't want to get too much into the weeds. Uh, it is like a negotiation that goes on between the seller and the buyer, really their accountants. The buyer wants to allocate a lot of that purchase price money towards furniture, fixtures, and equipment so they can depreciate it over a period of time. Most likely, that seller has already depreciated those assets. So any purchase price that gets allocated towards that, um, the seller, what they call, recaptures it. The seller's and it's treated as ordinary income. The game for the seller is to get as much as that purchase price um, treated as a capital gain because it's less taxes they're going to end up paying as opposed to any purchase price is allocated where the seller's got to pay ordinary income on it. They're going to pay more taxes on it. It's something that the accountants work out, and the accountant who knows what they're doing understands it. And it can work through the purchase price allocation. And there's a section right in the agreement. Purchase price is X, and then there's usually either it's in that agreement or there's an exhibit attached to the agreement where the parties agree to the allocation of the goodwill, the furniture, fixture, equipment, and maybe some other types of allocations that are there. Um, Representations and warranties of the seller. Um, if I'm representing the buyer, there's going to be a lot of representations and warranties of the seller. It's our ability to make sure there's no skeletons in the closet. The seller is going to represent that they have clear title to the assets. They paid their taxes. There's no employment liabilities creeping about. Um, the financial information that they give you was true and they gave you is true and accurate. Um, that if they're going to give you a client list or referrals or anything that they provided to you during the due diligence, all of it's true and accurate. There's no litigation. There's not no litigation that may be pending or threatened against them. Kind of fleshes all those out. Um, when I represent the seller, what do I want to do? I want to minimize those representations as much as possible. So instead of maybe there being 20 of them in the agreement, I'm trying to get them down to 10 or no or 15. Or as a sell, what is the game that gets played between the attorneys with the representations and warranties is if you're wearing your seller hat, the seller's attorney will say, well, to the best of my client's knowledge, this is true. Where we want to try to get what we call those knowledge qualifiers out of there. We want the seller to be making true, accurate statements and not to the best of their knowledge. I'm going to jump down to like joint and several liability. Also, when I'm representing a buyer, in the very beginning of that contract, it's going to say the contract is buying among the seller, which is probably going to be the entity. You always want to insert who the members or the principals of that entity are, the individuals, and then the buyer. Because when you get down to the representations and warranties, there's a section in the agreement. It's going to say that the seller and the principals represent and warrant to the buyer jointly and severally the following. You have all the representations in there. Why do you do that? Once you close on it, the day you close on a business, money goes into the seller's account. The seller can take that money and move it into some type of money market. So the business is still there, but it's like a shell. There's no assets to it. So what you want to do is in the event that when the business is sold, and the seller lied to you, made a misrepresentation, and you get your damage as a result of that, you want the ability not only to go after the business entity, which may just be a shell after we close, but you can go after the seller personally for the as much as you want. So that's the joint and several. It makes a big difference. And again, it's nothing that's unreasonable. Attorneys who are working, in the industry and on these types of contracts, they understand that that's a reasonable ask for an obvious reason. Indemnification, that's a fancy legal word. It's in every agreement. And the attorneys spend a lot of time on it. It's a fancy legal word. I always try to break it down as like this: if we close today, in 6 months from now, a claim is made against the business, and they sue you as the buyer, and they're going to sue the seller. But the claim is made 6 months after you close, and you're the new owner. But you look at the claim, it's like, I wasn't the owner then. That's when the seller was the owner. The seller is going to stand in front of you through indemnification and say, no, it's my responsibility, not the buyer's. I was the owner at the time. Same scenario, 6 months after closing, claim is made, but it's for a time when you were the owner during that short 6 month period. And they sue you as the new buyer and they sue the seller too. You're going to stand in front of that seller and say, no, it's not their fault, it's mine. I'm really simplifying it, but that's really indemnification in a nutshell. And in indemnification, there's a wall that goes up. The seller is responsible for everything that happened prior to the closing. While it's under watch, buyer takes over after their watch. And then indemnification just requires either party to hold the other one harmless upon a claim being made, um, as a result of whether there's a breach in the agreement, seller didn't pay their taxes, there's some type of claim that gets made by maybe an employee. Uh, it's a way to kind of shift liability. Um, Conditions of close, more doors for those doors that are in the LOI are baked into the purchase agreement. So you, as the buyer, you have the ability to get out of the purchase agreement, even though it's bound, because these conditions weren't satisfied. Maybe you find out that one of the reps and warranties that the seller made during during the period negotiating the contract or something comes up, that's not true. You're not satisfied with your due diligence. You didn't get to find, all of a sudden, you really don't, even though the bank was saying you're going to finance it all along, now you got a signed contract and you're bound by this contract, but you don't have the financing. You don't want to be forced to close because you don't have the money. And then maybe you can't get the real estate. Maybe the real estate contract falls through for some reason, or you can't negotiate the lease with that third party landlord that you want to get. You want the ability to get out of the deal. Um, you got the LOI, and then the LOI gets turned into a purchase agreement. You sign a purchase agreement. Then there's going to be a period of time in between the purchase agreement getting signed and the closing. So what do you want the seller to do during that period of time? You want the seller to maintain the business in the ordinary course, which is spelled out in the agreement. The last thing you want to do is the seller enters into an agreement with you and he or she puts their feet up on the desk like, oh, screw it. Now we're selling. I don't have to care anymore. Because when the day you get to the closing, you don't want any surprises. You want to have them maintain the business in the ordinary course. There's going to come a time once all the conditions are satisfied, meaning all the doors that you as a buyer can get out of, once they're closed, and then you're focused on, okay, now there's no way for the buyer to get out. Parties are focused on a closing date. That's typically when the seller will give the buyer the opportunity to talk with the seller's employees. Hey, and transition that relationship. They do that only because they know the seller doesn't want, if the seller's got their business on the market, they don't want to introduce their employees to numerous types of buyers. Once you're only introducing the employees once you got a firm buyer. Restricted covenants. A lot of chatter about restricted covenants not being enforceable. Um, they are enforceable in the sale of a business because you, as a buyer, are really buying the seller out of the market. Last thing you want to do is spend $1.2 million, on an ongoing business, only the seller to take that money and then go, across the street and start competing against you. So that's a big part of these agreements. Restricted coverage types, you have the non-compete. Usually you'll see anywhere from 3 to 5 years after a closing. There's a radius. The radius, this depends on where the clients are being drawn from. Where you're, if you're in a more urban setting, that radius is going to look different than as you're in more rural setting. It just depends. And then you have the closing with the restricted covenant. You got the non-compete, non-solicitation. You don't want the seller soliciting now that you're your employees. You don't want them doing that. You don't want them soliciting now your clients or your referral sources. That's all part of it. And then you have the closing date that's set in the purchase agreement. When are the parties going to close? And then, like guys know, we talked about at the outset, a transition period. Is there going to be one? What does that look like? All spelled out in the purchase agreement.
What does a typical timeline look like from like letter of intent to closing? Is that like
Yeah,
how
it
long? What's
depends.
a reasonable expectation?
I use a fancy legal word. It depends, right? Uh, it depends on, as a buyer's readiness to deal with the lender. I've had, unfortunately, again, I'll mention Live Oak, they're ready to go. You just got to get the information to them. With some buyers are kind of kicking the can and they're not getting the information, and the lender's kind of hands are tied unless you get them the financial information needed in order for them to process the loan, because that loan takes time. There's a lot of stuff that has to go on behind the scenes. Um, a good rule of thumb, 90, 90 to 120 days, somewhere along that line. It's going to be different um, from a timing perspective. If you're buying the business, seller owns the real estate, but is not selling it to you, they're going to enter into a lease. That's going to reduce time frame. Okay. Um, and it's going to be different if you're going to buy the business and you're buying your real estate, because typically when you're buying your real estate, as I mentioned, additional due diligence has to get made. Um, Doing a phase one environmental study on the real estate alone, those consultants usually earmark at least 30 days, from the time they're engaged and from the time when they're going to issue their report to us as your attorney. So that takes time. And also it's going to be a little different if you're buying the business. Seller doesn't own the real estate. An outside third party does, and then you're negotiating with a third party landlord who at the end of the day, a lot of times doesn't really care about the agreement between the buyer and seller. Or he or she doesn't care, or unfortunately, their attorney doesn't care. So it's a log jam in there. So it just depends. But I think, that's why you want to, I always, whether I'm representing the buyer or the seller, once you're ready to go forward, get the process going, because eventually the bank, remember who makes all the rules? They're going to have a time frame in there. They're going to give you a commitment with a rate, and that rate's going to lock in. And if you don't get the deal done within that period of time, you run the risk of even losing that commitment or the rate going up. You want to control your own destiny. So yeah, I think 60 if there's no real estate being bought, 60 days, the 90. If there's real estate involved, 120 days is a good time frame.
Do any of the environmental or surveys have like a time limit? Like this information is good for 60 days or whatever, or do those things just not change very much?
Yeah, so that's a great question. The surveys, last a long time, and if again, it depend on your bank. Uh, um, Banks are accepting it too. If a survey is dated, what's usually required is the owner of the property will provide an affidavit of no change. So survey's done, they go out, they survey the property, and then I don't know, something got delayed and you don't go ahead with the purchase, but maybe you come back, I don't know, a long time afterwards. Um, if the seller provides an affidavit of no change, meaning they haven't done anything to change the property layout, that should be no, there should be no issue there. On the environmental, the same thing. I don't remember off the top of my head if it's what the time frame is associated with that, but I haven't had an issue where buyers actually. I haven't had an issue where buyers got their pen in their hand, going forward with a deal, and all of a sudden puts it down, and then their survey or their environmental report has been outdated. I have had issues where maybe a buyer's coming in, not an issue, but where we're trying to use a seller's old survey. Maybe say the seller, the buyer some money, where we're trying to do that. And, we get the affidavit of no change. It's going to depend on whether the bank is going to accept that or not, or the bank's going to say, no, we need to get a new survey done. And same with the environmental report. It's going to really depend on the lender a lot of the times.
Okay, cool.
Or here, there. This kind of encapsulates everything we've been talking about. Failing the plan. You obviously want to plan when whether you're buying or you're selling. Rushing into negotiations, allowing for time delays. I think I really kind of touched on all of this. Not enough due diligence. The transition, is there going to be one? Your team, and then going back to the old deal fatigue. I can't tell you how many times, and I try, as a business attorney, I really want to accommodate, our client and get them to where they want to be. It's frustrating for us to see the frustration on them sometimes, especially when they're selling at the end, because there's, oh my God, the bank's asking me for this. The buyers, the buyer wants this, they want that, and then it's just they're getting poked and prodded in 10 different directions. You just want to be prepared for that. That's why you want to be organized going into the deal. Um, let's see. And then I really just want to really just kind of touch on, structuring, a startup. You I think the first thing you want to do is have an airtight business plan. What's the framework for opening your business and roadmap to success? Going back to your question about the time frame, where are you currently working? how that's going to, now what's that going to look like when you look to go open your business, and how long is it going to take to start up, you know, start it up. And if you're starting it up, are you going into an existing space that's got to get redeveloped, remodeled, or are you going to do a ground up construction project? What is that going to look like? Uh, Getting your, no, obtaining your financing. I can't, I can't emphasize this enough. Obviously, you can see everything kind of goes back to money, like in any other business, right? You're going to need the money, getting your financing, more importantly, from a lender who knows the industry. So and I'm going to end. I've had many times a clients. I emphasize because clients will come to me. Well, I got a friend, a community bank here, and it's just not the same. It's really just not the same at the end of the day. Getting your financing in place, selecting your location, working with a real estate professional, to understanding the demographic considerations, where you want your business to be, um, understanding the zoning regulations, what services are you going to provide there? Are you allowed to do it? And if you're not, are we able to get some type of a variance or some type of permission for you to do that? That's going to add time into the overall the plan. So you want to know that up front, what the use is that's the property is currently zoned for, what you're going to do it for, and then if the use is you're looking to get the use changed, one, how much time that's going to take, two, what's the cost involved in doing that, and three, what's the likelihood of success that's going to happen. Um, Real estate considerations. And again, I'm going back, if you're going to buy an existing building and you're going to, maybe it has some other use, but you're going to turn it into, a boarding or a kenneling or both, facility or a grooming facility. What's that going to look like? Or you're going to buy the building and do that same type of construction, or you're going to, buy a piece of dirt and do a ground up construction project. And then hiring your first employees and kind of getting understanding what that looks like in proper classification. I just had a conversation with a client yesterday asking me, does it matter, if I classify my employees, the people who are going to work for me as employees or independent contractors or consultants? It does matter. And you as a business owner, you just can't wave a magic wand and say, oh, Beth, you're going to be a consultant. And then Pete, you're going to be my employee. You can't do that. The IRS has a certain test that they apply to make sure that if you're going to classify somebody as a consultant, you hear the term consultant, independent contractor, or 1099, consultant, all the same thing. You got to satisfy a certain test as the employer that person qualifies to be classified like that. Because if you don't, and there's an issue down the road, you as the employer are going to be liable. What issues arise? A lot of times we see issues arise when that consultant that you misclassified is ticked off about something. You didn't pay him or they're upset, and then you fire him because they end up being a bad person. And then they go make a claim with the Department of Labor. The Department of Labor looks at it and says, well, Beth, well, it doesn't she worked full time for ABC Co. and she didn't work for anybody else, and she did that doesn't smell like an independent contractor. So they come in and they audit your business, and it's like a worm that goes in there. And you want to avoid that through a misclassification. And it is easy to avoid, again, with your attorney, your accountant working together as a team. There. That's just me. My contact information. I know Beth will share that with you. Um, and then yeah, that's it. So I appreciate that, the opportunity to provide the presentation. And if there's any questions, I'm happy to take them.
I actually have a question in case
Hmm.
anybody needs a minute to get theirs ready. Um, with the growing use of AI,
Hmm.
have you found in your interactions, professionally, have you noticed people trying to do things on their own, relying on AI for
Yes.
them rather than that?
Yeah.
And has that
Yeah.
turned into a dumpster fire or?
Yeah, it's funny you said that because we had a client yesterday that actually reach out and sent, there was four attachments to their email, and that email, you could obviously tell that the documents that are attached were all AI generated.
Mhm.
I know they mean well, and everybody's trying to save a buck. I think AI is a good tool a lot of times for, to get basic knowledge and start, a start of it. But it's not going to replace, I think the job, what, an attorney can do or the accountant can do. Um, and of course, I'm saying that because I'm an attorney, right? I think you need to AI is a good starting place, but like even when we say, we obviously we have attorneys here who go into AI and use it for something. It's a good starting place, but whatever AI generates, you got to understand what it generates. You can see whether or not it's true and accurate and it works, right? So maybe, hey, give me this. It spits something out. But if you don't understand what you're looking at, it's not really going to help you. So the last thing that you want to do is be penny wise and pound foolish. You know, you spend, spend some money up front to prevent issues down the road. I say that a lot of times with employee handbooks. Uh, the employee handbook is a shield for employers because you have all these employees that are working for you. That the handbook is, if it's drafted properly, can avoid or mitigate potential exposure for you as a business owner. You got an open door policy. There's a policy in place for discrimination. There's a policy in place in case the employee is harassed, not just by you, but maybe whoever's coming in and out of your business, and maybe that employee is being harassed and they're not telling you. Um, it's really the rules that are associated with the business. So yes, we do see it a lot. I think, so I only expect to see it more and more.
Mhm.
Um, and then we have a conversation with the client and say, listen, I saw what you brought over. This works. It does work, or it doesn't work, and these are the reasons. And then usually that conversation say, I understand. That makes sense.
Yeah. Well, I mean, AI, unless you're giving it an enormous amount of information, the conversations, and I would imagine a lot of these documents are so nuanced and specific and unique to the two parties involved, that it would be really difficult for a to that for that to be a reliable resource in this sort of fairly significant endeavor.
Yeah, you're spending a lot of money, and you obviously want to protect yourself, whether you're the buyer or the seller. I think there's a lot of moving parts. In a business transaction, I'll go back to the bank. A lot of the banks, well, in Live Oak in particular, they know that, right? So not only do they provide you a loan to buy the business and or the real estate, they're also providing well, a lot of times they'll provide finance like working capital. So there's X amount of dollars that you can borrow in order to help pay for your professionals. And like if you're buying the real estate, you're talking about doing that phase one title survey, building inspection. That's thousands of dollars, of expense, third party costs, not your accountant, not your lawyer, that you're paying the third parties that you may not have readily available. So no, you can end up borrowing that money over a period of time. You buy the business, you start making money on the business, you're paying it off.
Mhm. That is something that I've learned through posting all of these webinars is the value of using professionals who are professionals within the pet care industry. So, like construction, banks, lawyers who have done this specifically in the pet care industry so that they can guide you as you go through these big changes. They can say, have you done this? Or it would be great if you reached out to this person to help you with this part. You
Right,
don't know what you don't know. And so you're relying on people to tell you what you don't know.
right. Um, it's just being proactive. Like I said, as a business attorney, it's something, the last thing I want to do, I'm trying to minimize our clients' exposure, to issues down the road. And you spend the time, I would say you spend time and money up front, on a good drafted agreement, when it's got to be enforced or implemented, it's gonna help one side out of the other. I also one other I didn't touch on, but partners. You and I are gonna go buy a pet care business together. One other added layer in there too is our agreement,
Mhm.
right? That you and I are going to have. I do find a lot of times clients, don't put enough emphasis on that. The problem with that is, you and I are getting along great right now. We took out a massive loan, right? We're buying the business, and all of a sudden, 3 years from now, you don't like what I'm doing anymore, or I just checked out. You know what, Beth? I don't want to come anymore. I'll be there a day or two. I don't really want it, but I still want to get my distribution. I want, but I don't want to do, right? You don't have, a well-drafted partnership agreement can, while you and I are on good terms, it's like a prenup. So who's going to be responsible for the day-to-day operation of the business? What decisions are going to be require unanimous consent? You and I are 50-50. What happens if you and I can't agree? You want to expand, and spend X money on an expansion. I don't want to agree upon it. What if we can't agree? We don't want to sue each other. There
Mhm.
should be a mechanism in there that we agree upon while we're in good terms that allows us for a disagreement. Or if I want to quit, I want to get out. Um, it's mapped out in there. Again, going back to how the business is valued, because that's the first step. Finding it. So that's a really important part. And I didn't really touch on that, but if you're going to go into the business with a partner, um, not so much if it's your spouse, but if it's somebody unrelated third party, if there's a good friend, definitely spend a good amount of time on that partnership agreement, um, because when things go wrong, you want to take dust that off and say, hey, when we were on good terms, things were working. It's all mapped out in there, and you can spell it out.
Mhm. Yeah, that's super important. And I bet you that's a part that is realized more in hindsight than it should be.
It is, unless to your point, you're working with professionals. A lot of times, if we're not involved, the accountant will say, "Well, geez, Beth, and your partners with John, Mary, you guys have a partnership agreement in place." Nah, we don't need it. The bank doesn't really require so much. Spend the time on it, because the bank requires a partnership agreement, but it's not their job to get into the weeds on what the terms and conditions are. They're just looking to have something check the box.
Right.
Obviously, they want your partnership to work out, but they're not lawyers. That's not what they're doing. It's your lawyer's job to say, okay, this is what the business is. Let's talk about what you envision your business to do. What happens if one of what happens if somebody dies? Now, I want to be your partner, but if I die, you don't want to be partners with my wife. And it's very easy to spell it all out in there like a roadmap.
Mhm. Awesome. So in the beginning of your presentation, you mentioned that you can help your clients from start to finish, basically.
Yeah.
So even beyond the business acquisition or startup, if they have questions about, what are they legally required to provide their employees, their staff, like pro liability stuff, those are all things they can still refer to you to?
Yeah, 100%. That's where we spend a lot of time with our clients
Yeah.
who are ongoing um, business owners. So that's why I love what I do. Almost like when we work with our client, they buy it or they start up the business, then we're their outside general counsel, and it happens on a regular basis. They're going to bring on an employee. And a lot of times in this industry, you don't have employment agreements in place. Maybe there's a key employee that you want to have. It's not usual, but if you won't do, we'd have a conversation around it. But the classification issue, or just workman's comp issues, all a lot of time, maternity related issues, things like that. We can help out with all those.
Have you yet had one client that's gone from start to finish where you helped them acquire the business and then help them exit also?
No, not yet, only because I've only really gotten really involved in the industry over the last, I'd say, 3.5, 4 years.
Okay.
So it's pretty, I still relative we've worked with a lot of clients starting up new builds and even acquiring. So it's ongoing now. And then, I think they're still kind of, they're in the midst of, they're in the heart of what they're doing. They still got loans to pay off. But no, I haven't gone through. all that yet with them. I haven't gone through an actual sale with somebody yet on that side. The sales that we've done, I've
Mhm.
been brought to us to work on by just they weren't existing clients before.
Gotcha. That would be, I think, feel like that would be a pretty notable moment, a milestone for sure, if you've gotten a
Oh
client from
yeah. I had
anywhere
so
Texas.
not in this industry. So we've got we really thought it was important or an opportunity for us to get involved in here was about 4 years ago, and we pivoted like a lot of I think other professionals. What we have a very deep base in the veterinary space like Live Oak does, and I know TWC does. Um, and then we saw an opportunity here where there's a need for legal. So in that space there, yes, I've been working in for over 15 years. It is very gratifying to work with someone who don't and retain you at the very beginning, whether it is a startup or an acquisition, and now you're working with them to sell. I actually have one right now. I just got another one. Um, just got a letter of intent for their practice to be sold. And actually, they're a relatively young couple, but they've been a client for a long time. And we've done all different types of, and they're located out west, and we've done all different types of things, and especially a lot of employment stuff. Because I find with any business. It's the staff. It's for the business owners. It's just like you scratch your head sometimes. Even law firms, accounting firms, any business or widget company, the staff is a big issue, and employers don't know
Hmm.
what to do. And that also over the last, I'd say, last 10 years, personal injury used to be a big driver for money, which still is, but there's a lot of um, plaintiffs employment lawyers out there where you get a disgruntled employee and they get and a plaintiff's employment lawyer gets their ear. Well, you can Beth did that. Oh, we can try and squeeze some money out of Beth. It happens unfortunately. And we've seen that more and more. So you want to try to be proactive and mitigate those types of that type of exposure.
Yeah, those are, I think, they keep any business owner up at night, I'm sure.
Yeah. Especially, it's like a catch-22 because you want your business to grow, but along with that growth, that potential issue comes.
Yep. Yeah, you get a little bit more vulnerable the bigger you are.
Yeah.
Yeah. Well, I don't want to take up too much more of your time. You've been so generous with us so
Yep.
far, and thank you so much. I think this was extremely informative, and I feel like there are probably a number of different topics that we could talk about. Um,
Yeah. Well, we
I'm
could.
really
Yeah.
grateful that you gave us your time.
Yeah. Well, thanks for having me, Beth. And maybe listen. We could always have another one. We can drill down on something. And to any of your, your, listeners, you can always reach out. Please. Advice is we always willing to have the conversation with a client and then understand what the scope of work is going to be, talk with them about it, and put a budget around it. So
Yeah,
there's no fear about reaching out.
perfect. And I have
All
your
right.
contact information shared, and it'll be on the landing page as soon as the recording gets
Yeah.
posted.
Thanks, Beth.
Thank you so
Great
much.
seeing
It was
you.
great
All
talking
right.
with you.
Likewise. Thank you. Bye bye.
Bye.